Welcome to You and the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar. I have my own firm, Barry L. Gordon and Associates, where we concentrate in family law, personal injury, and medical malpractice. Today's show is a real eye-opener, and maybe one of the first of many shows and lectures that you're going to hear regarding the new maintenance amendments or the new maintenance statute that goes into effect January 1st of 2015. So pay attention. On January 1st, the amendments to the new maintenance statute in Illinois are going to be amendments to sections 504 and 505 of the Dissolution Act in Illinois. And for those out there that are not attorneys, we are amending the maintenance statute. Maintenance means support for one of the spouses. It used to be called alimony. And it's important that you listen to this program because these changes are going to be really drastic. The most important aspect of these amendments is the new formula or guidelines, or we can call them calculations, that the legislatures have come up with to define the appropriate amount of maintenance. The statute talks about, first, the court or the judges must determine whether or not maintenance awards are appropriate in that particular case. And there is a list of characters or a list of guidelines that they have to use. And basically, they'll be using the old statute guidelines, and we're going to be talking about that in a little while. The new formula or guidelines are going to apply to spouses who have a combined gross income of less than $250,000. Now, the formula goes on to say that 30% of the payor, that's the person paying, 30% of the payor's gross minus 20% of the payee's gross, payee means the person receiving. So let's say that again, 30% of the payor's gross minus 20% of the payee's gross, add them both together, and it cannot be in excess of 40% of the combined gross of the payee's gross. The legislature went on to define the duration of the award. In other words, how long does the payor, the person paying, have to pay maintenance? Under the old law, if generally speaking, the courts held that if the marriage was less than 3 years, then it usually would not be appropriate to award maintenance to one of the spouses. There were exceptions to that, especially if there was a challenged person involved, somebody that was very ill, somebody that was a paraplegic, or the like. Now, under the new amendment, 0.5 or less than 5 years, the figure of 20% is going to be used, and I'm going to explain that in a moment. 5-10 years would be 40%, and 10-15 years, 60%, and 15-20 years, 80%. So for example, where it says 5-10 years, 40%, we take 40% of a 9-year marriage. If we had a 9-year marriage, 40%, and that would equal, if we multiplied 40 times in 9 years, 3.60 or almost 3.5 years, a little over 3.5 years. That's how long the maintenance would be lasting. That's how long the payor would have to pay it. Now, the court has full discretion in marriages of 20 years or more, and they can order permanent maintenance or maintenance equal to the length of the marriage. The statute goes on to talk about other things that we're not going to talk about in this program today. It goes on to define interest on maintenance, maintenance judgments, maintenance during appeal, maintenance during imprisonment, and fees to the clerk, and maintenance secured by life insurance, as well as many other aspects. But today we're only going to concentrate on these guidelines that the court has come up with. And as we go along, we're going to define that for the lay people out there who are not experts, who are not attorneys, so they have an understanding. We have two expert panelists here today, and I mean expert because these are the people that were involved in this new law coming to place in January of 2015. They've been on the subcommittees of the bar associations. They have talked to the legislatures, and they've testified. And these are the people that are very important. Hopefully we'll be able to find out what motivated the legislature in Illinois and all the other bar associations, the Chicago Bar, the Illinois Bar, Illinois State Bar, and the American Academy of Matrimonial Lawyers, and so forth, to come up with these new guidelines. To my left is Jackie Birnbaum. Thank you for being here today.
Oh, it's my pleasure.
She's from Birnbaum, Haddon, Gelfman, and Arnoux. And to my right is David Hopkins. David's of the firm of Schiller, DuCanto, and Fleck. Thank you for being here today.
It's my privilege. Thank you.
Okay. So the first thing we're going to discuss is the formula. Can you explain it a little better than I did?
Well,
Jackie?
Trying to explain this in a way that's accessible and reasonable it's so important. So let me explain. The first thing you have to do is to find out what the combined total gross income is for the payor and the payee. Here's an example. Let's say you have the payor earns $50,000 a year and the payee $30,000 a year. So you have a combined gross income of $80,000 a year. So let's figure out what the cap on this would be before we do anything else. An award can't exceed 40% of their combined gross income. So that number would be $32,000. So if you take $32,000 would be the most that would go to the payee. She already makes $30,000, so the award under the cap is $2,000 a year. Now, step 2, find out what would be the calculated amount. And the calculated amount would be the payor's gross income, $50,000 times 30% is $15,000. The payee's gross income is $30,000 times 20% is $6,000. So $15,000 less $6,000 would be $9,000. So the calculated amount would be $9,000 in maintenance. But this is the big deal here, is that we have a cross-check. You have a $9,000 award that's calculated, but the cap is $2,000. So she would be getting, if the payee is a she, the payee would be getting $2,000 because it's which is the amount to consider is the award cannot exceed the cap. So this is a real important thing. Figure out what the gross income is, figure out what the cap is, then figure out what the calculated amount is, and then you can come up with a reference point where you can start. This is the most important thing, and we'll get into it later, but there has never been a place to start a calculation of what maintenance is. We've always had to start from scratch, so there was a lot of inconsistency.
So that the viewing audience clearly understands it in a different form. You take let's assume the payor is the husband, and let's assume that the payee is the wife. So the husband's gross is $50,000. You're going to take 30% of that first, which is going to be $15,000. Then you're going to take the wife's gross, which hypothetically is $30,000. You're going to take 20% of that, which is $6,000. You're going to subtract the $6,000 from the husband's $15,000, and you come up with $9,000. Now you put that aside for a moment in your calculations, and you're going to now find out what the cap is, which is 40% of the combined gross. So the combined gross was the $50,000 the husband was earning and the $30,000 the wife was earning, and we multiply 40 times that 80, and that comes up with $32,000, correct?
Right.
Okay. Now I'm going to have David finish that.
Well, I think it's important to bear in mind for simplicity purposes that there's a 30% rule, a 20% rule, and a 40% rule. Once you work your way through the mechanics of each of the 3% rules, you've got it. There's simplicity with these guidelines. A court can deviate from them with appropriate findings, but mastering the guidelines is simple once you understand the mechanics of each of the percentage rules.
All right. Now, we've explained the simple mechanics of how you arrive to what we arrived at as to what the wife is going to receive by maintenance. Now we're going to talk about how this all came about. We'll start with you, David Hopkins. David, tell me, you tried to achieve in coming up with a formula for maintenance.
We were trying to deal conscientiously with the worst problem in spousal support awards in Illinois, and that's inconsistency. From case to case, courtroom to courtroom, region to region, very inconsistent results were achieved in litigated cases, and the inconsistency was at great extreme. This bred disrespect for the judicial system. It also made settlement very difficult to achieve in many cases that really didn't justify otherwise protracted litigation. And the problem is the subjectivity of prior law, existing law, through the end of December of this year led to the inconsistency, and nobody had a common starting point for analysis. So the real goal was to get to the starting point for everybody to utilize.
All right, Jackie, when a client came into your office and you got all the facts and you spent a couple hours, you had to make some comments to that client as to where we're going. And obviously it was very difficult for you to determine what she would receive of maintenance or what she'd have to pay the husband, as she could have been the big wage earner. We don't know.
That's true.
And does this help you?
Oh, sure. Because what happens now is that at least there's a place to start. At least there's a place to understand where to begin, because in the factors that were listed, there was tremendous subjectivity, and a court could have courtroom to courtroom, again, as David said, region to region, county to county. You could look at exactly the same factors, and without a place to start, the subjectivity was too great.
All right, this way you could pick up the telephone, you can call the opposing counsel, and you can say, hey, look, he earns X and she earns X, and if we use this formula, he's going to have to pay or she's going to have to pay. And you had a starting point, at least you know exactly where you're going.
Well, you know where you're starting, because then you can use, if there's, based on the facts of a case, and each case is different, then you can look at how you can use the factors to vary. But at least you have a place to start.
And of course, the court or the judge would have discretion in certain areas. So you really weren't 100% sure of the formula flying. We'll call it flying, all right? And is that a fair statement to make?
I don't know what you mean by flying.
Well, I mean that the judge would go with the formula. He has some discretion not to. Okay.
Sure.
All right. Now, how did this topic come up in the committees?
Well, originally David and I, we were on the maintenance committee of the Illinois State Bar Association, and our original thought was just to change the statute and tweak some of the factors that you had talked about that were listed. And the reaction from the council was clear, is that they wanted consistency. They wanted consistency. And so we were sent back to the drawing board, and that's when the study from the American Academy of Matrimonial Lawyers, there was a comprehensive study that was done in 2007. And it was a seminal reference point, and that's one of the things that we turned to.
All right. Can we, David, compare this to the guidelines that have been set for a long time now regarding child support? I mean, child support having guidelines was a big advantage to the legal community, was it not?
It produced consistency and a uniform starting place, and these were goals we sought in the maintenance area. But any form of guidelines in maintenance is far more complicated, because there is such differences between family consumption in this case versus that case. There are many other distinguishing factors. We needed to use a somewhat different approach. And yes, there is the mechanical element to these guidelines, but the presumption in favor of the guidelines is as mild as can be, and there is to be no adverse impact on creative lawyering and discretion on the part of judges. As Jackie has stressed, the #1 goal is to arrive at a uniform starting point for analysis, and you go from there.
Okay. I want to mention first to a viewing audience that we have two of the finest lawyers in the state of Illinois here, who really, and let me just say why, because David, I understand you went to Columbia University, you went to Duke, you got a Bachelor of Arts degree or an AB from Duke, and Columbia you got a JD, Juris Doctor. You're a partner now in Schiller, DuCanto, and Fleck. And you're a member of not only the American Bar, the Illinois Bar, Chicago Bar, American Academy of Matrimonial Lawyers, and many, many committees have you been a chair. You've been a chairman of Chicago Bar Association Domestic Relations subcommittees. You've been chairman of Matrimonial Law Committee. You've been a member of the Committee on Courts and so forth, and we can go on and on and on. And this is really one of the reasons why you were selected as one of the people to participate in coming up with this statute. And as far as you go, Jackie, I have the same accolades for you. You're with Birnbaum, Haddon, Gelfman, and Arnoux, I think it's pronounced. Arnoux, I'm sorry. And you've been a super lawyer in many capacities. In 2010, 2011, you were listed as top 50 consumer lawyers in Illinois, is that right?
Yep.
And also in 2011, top 10 women divorce lawyers in Illinois.
Yep.
You've been involved in many, many lectures and seminars that you've led, and therefore you have been one of the top people in the state also in divorce and family law. So now we're going to continue on with some of the problems that the statute has, we'll say, resulted in, and we're going to talk about now the calculation for the duration of this maintenance. As I indicated in the beginning of this program, if there was a 5-year marriage, that would be equal to 20%, and 5 to 10 would be equal to 40. We used the example in the beginning of the program that if it was a 9-year marriage, you would multiply 9 times the 40%. Is that correct? Does this mean that the maintenance is paid in that instance, the 9 years, would that be paid for 3.5 years or 3.5 months, or how does that work?
No, it would be for the 3.5 years. But again, these are starting points and these are guidelines. There are other reasons that maintenance would terminate elsewhere in the statute. That doesn't affect it. And there are also, this is another big change in the statute that is very important. Before, the courts didn't have the ability to set maintenance for a fixed term. And now in marriages under 10 years, the court can fix maintenance for a fixed term. And you can't come into this court or any other court and seek further support. This is a brand new thing. There are other ways that it's still going to be.
Well, can it be reviewed after the term?
No.
You cannot?
No. If for only marriages under 10 years. And that's a change in the statute as well.
Okay.
So these are, again, and it's so important that these are, the statute was designed to be permissive. It gives everyone, the judges, the lawyers, the litigants, a place to start. But it was not designed to hamstring the discretion of the court to make variances for shorter, for longer, but this is, again, the place to start.
As I said at the beginning of the show, there were many factors, and I'm going to just go over them very briefly so that the viewing audience understands what a judge has to take into consideration, or should take into consideration, or wants to take into consideration. The income of the parties, needs of the parties, future earnings, impairment of present and future earnings, education, training, and employment, standard of living, duration, age, the physics and emotional condition of the parties, tax consequences, very important, contribution and services by the parties seeking maintenance, valid agreements that the parties make themselves.
Right.
Other factors that are just and equitable, that's a catch-all, that they can actually use any other thing that any other aspect that they think is appropriate in determining whether or not these guidelines will apply and what the maintenance should be. All right, now, having said that, that's not built into it's built into the formula that we just talked about. So there is that percent, we'll call it, of discretion that the judge has. Is that a fair statement? That the judge has discretion, assuming that they look at all those factors?
Right.
Okay. All right. Now, what about under the past law, if we had unallocated maintenance and child support? And unallocated maintenance means this, that child support and maintenance would be lumped together and would be one figure. And at that time, prior law, it would be deductible. Now, tell me about, I'll have you, David, explain to me this unallocated maintenance that and child support we've had in the past. We called it unallocated maintenance. How is that affected by this new statute?
The goal of the legislation is to put responsibility on the parties and their attorneys for working out the specifics of unallocated maintenance. Doesn't mean the court can't order it, but the parties have to at least stipulate. If there's otherwise a contest, they can agree, whatever you decide, Judge, in family support, make it unallocated, we so stipulate, and then the court can do it.
All right, let's go back, Jackie, to our formula, and let's assume that the husband was earning $50,000 a year when this formula took place and when he got divorced, and we know that the wife is going to be receiving $2,000 in maintenance from our calculations. Now, we find out that 5, 6 years later, he's not making $50,000 a year. He's only making $25,000 a year. How is, if it can be, is that going to be modified?
There are separate statutory arrangements for a modification.
Okay.
So, what we're dealing with when we come up with an award are facts at that time. If it turns out that there are changes, substantial changes in circumstances, then what happens is that you can go back to the court under the rules that exist.
Yes.
And petition based on new circumstances.
Okay, so it's not something that's put into stone. So as to speak.
See, everything depends, because there are certain ways to make it so that it's not modifiable.
Right.
And there are ways to make it that it is modifiable.
And the judge will hear the case.
Of course.
And he will decide based upon those factors. Yes, Dave.
I would just add that at modification time, the court would have discretion to consider what guidelines would be in the new circumstances, but the court is not mandated to employ the guidelines.
Okay. Now, we're going to talk about the legislation takes effect on January the 1st of 2015, correct?
Yes.
All right. How does this going to affect cases that are in process at that time? Cases are going on now.
I'm going to hand that one off to Dave.
Okay, Dave, you got the ball.
Well, as a generalization, it would appear under applicable Illinois decisions that with a pending case, the guidelines, the new legislation in general would be applicable. The question is whether new legislation has what's called by the Illinois Supreme Court as a retroactive impact. And there is no constitutional entitlement to the provisions of law that were in existence on the day the dissolution petition was filed. So if there was a petition filed in 2014, the case is adjudicated in March of 2015, there would be applicable, the new law would be generally applicable. If there was an adjudication December 15th, 2014, and since there's the possibility of what's called a post-trial motion asking the judge to reconsider if one were filed in early January 2015, the guidelines would not be applicable, or the new law would not be applicable, because that would be changing rights that were fixed prior to the effective date.
Okay, now, you gave a very technical answer, and I'm going to just make it a little simpler. It's certainly going to depend upon the judge, it's going to depend upon the court, and we have rules under laws called substantive and procedure, and they're going to look at that, and they're also going to look at what took place in the case before January 1st. And certainly if very substantive type of decisions were made, they're probably not going to change those. So we really don't know is the answer. Is that correct? Fair statement, Jackie?
The fair statement is that if a case, if the people have gotten divorced before the statute takes effect, it's probably clean.
That's going to be in
That's
stone.
probably clean.
Yeah.
If the case is continuing on after,
that's what we're talking
you're
about.
probably going to be, you'll probably have the guidelines considered.
Okay, they will be considered and maybe not absolutely, we'll say, changed. We don't know at that time. I think that we have had a very thorough discussion on this statute. It is a little, when you first hear it, a little complicated, correct?
A little bit.
And I think that after it's workable and we see what happens after January 1st, the judges may all have a talk themselves and see where they're going. So it's going to be quite new when it comes about, and I think that we're going to have a lot of questions that are going to be answered and a lot of questions that are not going to be answered. I want to thank all of you for being here today, both you, Jackie Birnbaum, and David Hopkins, and you both have really contributed not only in having this statute effectively passed by the legislature, but certainly you were a great help in this show in defining it all for the viewing audience, whether they be lawyers or whether they be judges. So thank you all for watching You and the Law, a program sponsored by the Chicago Bar Association.